You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com. It's also on the Bloomberg terminal. Welcome.
Good day.
So, Bill, there have been a dearth of interesting bankruptcy cases for us to discuss in recent months. So thank goodness we have several significant court opinions with wide-ranging effect on bankruptcy. Bill, let's start by talking about the bankruptcy case the Supreme Court is taking on.
Yes, sir, Bob. The seemingly big one, there are going to be two this coming term, is called Executive Benefits Life versus Arkansas. This case is to decide whether the right that somebody has to have a final decision on a state court lawsuit can be waived, that is to say, a final decision from a federal district judge as opposed to a bankruptcy judge. I wrote a big, long piece about this, Lee, in my column on the 26th of June, for those in the audience who'd like to go out and read it, because I think this case could go a long way to decide whether bankruptcy judges, although they sit up there in courtrooms wearing robes, are really little more than federal agency officials. Mm-hmm. This is just one of what may be quite a few decisions in the bankruptcy arena, limiting the power of bankruptcy judges who very possibly really don't have as much power as we think they do. The second case, although seemingly on a very, very narrow issue, actually could end up being much broader depending upon how the Supreme Court handles it. This is a case called Law versus Siegel, and the narrow issue in that case is whether a bankruptcy court has power to take exempt property away from an individual bankrupt who has misbehaved. This case actually, depending upon how the Supreme Court writes its decision, could have very broad-ranging effect in giving contours to what federal law calls the All Writs Act, which gives courts of all kinds, all federal courts, not just bankruptcy courts, the power to achieve a result which seems to be necessary or equitable. We'll have to sit back and see what happens. I think both of these cases probably going to be argued sometime in the November to early January area. That means decisions are going to start coming down maybe as soon as the first of the year.
And we have a new filing to report. This time it's a shipping line that has 17 practically new vessels. They filed for Chapter 11 in Houston.
Right.
Shipping cases, we've seen an awful lot of them in recent months. What's unusual about this case?
Well, this is the, so far, I think, most extreme of all of the shipping line cases we have seen, where the bankrupt company has virtually no, and I repeat, no connections with the United States. They filed this case in Houston. It's before a really wonderful bankruptcy judge named Marvin Isgur. And I think poor old Judge Isgur is going to be hard-pressed to keep his tongs on this case because they really resorted to filing bankruptcy as a last resort. Creditors around the world had seized 7 of their 17 vessels for non-payment of various debts. And it remains to be seen whether Judge Isgur is going to say that he, a bankruptcy judge in Houston, Texas, has basically worldwide power over the assets of a company which really has perhaps almost nothing in the way of connections with the United States. There have been several of these maritime cases that have so far succeeded in using the bankruptcy courts, but this could prove to be a situation in which this debtor, called TMT Group, has just stretched the rubber band a little bit too far.
And finally, we have some advance sheets to go over. The courts were busy in the last week with 3 new important decisions. Tell us about them.
Well, actually, you know, they have been busy this time of year. It may well be simply because their clerks are about to turn into pumpkins because the new graduates are coming out of law school and their old clerks are leaving, and so they've got to get these...
A little house cleaning.
They got to get these decisions out before their seasoned clerks leave them forever. The first case is one that the Madoff trustee lost in the U.S. Court of Appeals in New York in a decision written by Chief Judge Dennis Jacobs. This case dealt with whether or not the Madoff trustee could bring lawsuits against a whole bunch of huge banks like HSBC, JP Morgan, and others who were allegedly, and I repeat the word allegedly, complicit in or knew that Mr. Madoff was conducting a fraud. Judge Jacobs held that the Madoff trustee has no power to bring the claims that actually belong to the individual creditors. What I found fascinating, absolutely fascinating about this opinion came very close to the end in what I will call an apologia by Chief Judge Jacobs, where he said, rather bluntly, that the law might be better if the bankruptcy trustee could bring these claims on behalf of everybody. But he said that is not the way the law is now. It's up to the legislatures to change it. I am very eager to see if indeed the legislatures will take up Judge Jacobs on what he said and maybe give trustees better powers to make recoveries. Another really important case is from the Eighth Circuit Court of Appeals. This is, how can we put it, Lee? An effort to clean up some of the mess that began 20 or 30 years ago with respect to trademark licenses, where it was initially held that if you have a trademark license and the person who gave you the license goes bankrupt, you can lose the right to use that license. As we sit here right now, there are a split of circuits. There was a 2-to-1 decision in the Eighth Circuit which held that yes, you can cut off the right to use trademark licenses. And it is very possible that when they rehear this case, as they're going to do with all of the active judges on the Eighth Circuit, that it could go the other way, and we will therefore give some comfort to people with trademark licenses that they won't lose those rights once they go into bankruptcy. If, on the other hand, the decision comes down the same way, we will have a split of circuits, and guess what, Lee? About a year from now, we'll be talking about the very same issue going to the Supreme Court. The last is an issue that affects Wall Street. This was a decision just this week by bankruptcy judge James Peck in the liquidation of the Lehman brokerage. He held that if you have a plain common garden variety repo agreement with a broker that goes bust, you do not have a customer claim. Now, for those of you who don't know what a customer claim is or what it means and why it's important, well, I'm not going to explain now because it probably doesn't matter to you. If, however, you're on the street and you understand the importance of a customer claim, then you will know why this decision is really quite important. However, I'm not going to get in detail because as sure as God made little green apples, this decision is going to be appealed to a district judge and finally to the U.S. Court of Appeals. And I suspect, Lee, we're going to be talking about repos and bankruptcies again sometime in the next year.
Right on. Stay tuned. Bill, thanks for that. That's Bloomberg News Bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases or issues we just ran through, be sure to go and read Bill's column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. You can see more of our videos on YouTube. You can follow our updates, of course, on Twitter. I'm Lee Pacchia. Thanks for watching.